Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. We'll update you on the big commercial legal news stories in less than 13 minutes. Ever since the landmark case that gave individuals the right to have Google links to information about them removed in certain instances, known as the right to be forgotten, Google has been inundated with delisting requests. The Advisory Council to Google has now issued guidance which summarises the criteria that should be used for delisting requests. The Council has identified 4 sets of criteria to be used by Google when considering such requests. None of these 4 are determinative by themselves. The criteria is the data subject's role in public life, the nature of the information, public or private interest, the source of information and motivation for publishing it, and the timing and the relevance of the information. The Council has also made it clear that the protection of human rights is a responsibility of the state, and in these cases where there are limitations to these rights, it is the state rather than Google which must make the decision. The continuing trend towards bring your own device policies, which allows employees to use their own electronic devices rather than their employers', offers many advantages, not least the possible cost savings, and as it is something that's often requested by workers, it should help to boost employee engagement. Any implementation of a bring your own device policy does require careful thought to ensure that the data security risks that will inevitably arise are properly managed, such as ensuring that the devices are properly protected against viruses and that there is appropriate encryption software to protect against data being exposed if a device is lost or stolen. The Working Group on Data Protection in Telecoms has now published a working paper providing guidance on the privacy and security risks that organisations must address before allowing their employees to use personal devices. The ICO also has guidance which is available on its website, and the links to these papers are available on the written version of this bulletin. When travelling internationally, we may often feel that the transportation does not meet the same safety standards that we have come to expect as normal back at home. But what may not be quite so obvious is the extent of the employer's duty to conduct risk assessments for its travelling employees. In the recent case of Dussek and Storm Harbour Securities, where Mr. Dussek was tragically killed in a helicopter crash in Peru, it was held that his employer was liable as it had failed to undertake a reasonable risk assessment. The court found that even brief inquiries by the employer would have identified that the helicopter was unsuitable, was flying a route that was inherently dangerous in bad weather, and the flight was operated by a company in financial difficulties. For companies that have employees travelling on company business, this case makes it clear that it's no longer simply a case of booking some flight tickets. A risk assessment must be undertaken, which may not be a simple exercise, particularly when the travel is to destinations where health and safety regulations are not at the same standards that are the norm in the UK. As many of you will be aware, the loss of Woolworths from our high street also ignited a debate over the EU Collective Redundancies Directive and whether 1, the UK government had correctly interpreted the directive, and 2, whether the trigger for collective consultations is 20 or more redundancies within 90 days from one location or from the entity as a whole. The Employment Appeals Tribunal, the EAT, decision in the Woolworths case was that the whole entity was relevant rather than the individual stores. However, the Advocate General of the European Court of Justice has now issued an opinion disagreeing with the EAT and noting that the aim of the directive was to protect workers where large numbers of redundancies were being made. This meant that the establishment in question had to be local employment. We'll have to wait and see if the European Court of Justice follows the Advocate General's opinion, which is the norm but not obligatory. This may take another 6 months, and until then we are stuck with the Woolworths decision. In the last few weeks, there have been a few reminders about the need for clarity and honesty in advertising. The Internet Advertising Bureau has issued guidance on native advertising. TripAdvisor has been fined $500,000 by the Italian Competition Authority, the AGCM, for misleading advertising claims. And advertisers have been reminded by the Committee of Advertising Practice, the CAP, that they need to be clear with their online marketing to children. Native advertising is a form of online advertising that matches the form and function of a platform on which it appears. This can be in many different guises, For example, it may be ads that appear alongside search results, sponsored tweets and adverts that have a look and feel of editorial content. Two of the key guidelines for native advertising formats are: 1. Provide consumers with prominent visual cues, enabling them to immediately understand that they are engaging with marketing content, e.g. brand logos, and 2. It must be labelled using wording that demonstrates a commercial arrangement is in place, e.g. paid promotion or brought to you by. Now, TripAdvisor may be feeling it has been harshly treated by the Italian competition authorities, as it was accepted that it does have stringent measures to ensure that published reviews are not fake. Nevertheless, the authority deemed that the checks are not sufficient to support TripAdvisor's claims that the reviews on the sites are true and reliable. There is a liability exemption for hosting providers prescribed by the EU e-commerce directive, but it was held that this was not applicable to TripAdvisor because its services extended beyond just providing a platform. It also provides a ranking tool. The activity that we have seen here and a regular monthly list of advertising standard authority actions demonstrate that just ensuring adverts are correct is not sufficient. Advertisers must instead consider any risks of the adverts being misleading or not completely transparent, and then ensure that they plug such gaps. This case concerns Forney Golf Club's right to terminate. Although a contract was not signed, there was a draft in circulation since 2009, and it was accepted that the draft represented the terms of the agreement between the parties. Clause 4 of that agreement provided, in order for this contract to be reasonable for both parties to develop and invest in a viable business development plan, an initial term of 3 years, with the fee to be reviewed annually, must be agreed. Clause 6 then followed with the termination, and in particular that either party could terminate the agreement without giving reason in writing, giving 4 months' notice, or any such period that was mutual to both parties. In 2010, the golf club gave notice to terminate the agreement, and the following day Myers Catering ceased to provide catering services at the club. The golf club brought proceedings claiming sums alleged to be due from Myers Catering. Myers Catering counterclaimed for damages for repudiatory breach of the contract. Myers Catering argued that the agreement provided for an initial term of 3 years, terminable thereafter by either party on 4 months' notice. The golf club claimed that it was for a fixed term of 3 years, but terminable nonetheless at any time by 4 months' notice within the initial 3 years. The golf club initially triumphed at court, but Myers Catering successfully appealed, arguing that the judge had failed to understand what a layman would have understood from reading the terms, and that initial term would naturally convey to a layperson a fixed term which continued thereafter for as long as the parties might wish. It is easy to see how both conclusions could be reached, given the ambiguous words of the contract, and this illustrates the importance of clear drafting to avoid costly court trials. The recent High Court case of Sebri versus Companies House is a case that demonstrates how cataclysmic consequences can arise from a simple administrative error. In this case, Companies House had accidentally registered Taylor & Sons Limited as being in liquidation instead of Taylor & Son Limited. Before the mistake was realised, the information had already been disseminated both by word of mouth and via Companies House bulk products, i.e. services such as Experian and Dun & Bradstreet. As a result of the negative publicity this created, the company lost key contracts, supplier credit terms and cash advances from its bank, which quickly led to the company filing for its own administration. It is understood that Companies House had correct procedures in place for checking, but they admit they failed to follow them. This is certainly a lesson for all of us in the importance of checking the detail. Fresh Trading Limited, which trades as Innocence Movies, had a legal battle over the intellectual property in the logo that depicts the outline of a simple face that is topped by a halo. The logo was designed by an external design company called Deep End Design in 1998 in return for a shareholding in Innocence Movies. Deep End Design went into liquidation and the shares were never allotted to it. The rights to the logo that were owned by Deep End Design were purchased from the liquidator and transferred to a new company called Deep End Fresh Recovery, which applied to invalidate Innocent's EU Community trademark for the logo by arguing that it owned the copyright to it. As a result, the EU trademark action was stayed pending the determination of the UK copyright action. The relevant piece of the wording from the contract read as follows: Fresh receive full intellectual copyright of any work, creative idea or otherwise, presented by the agency and then subsequently approved by Fresh. Work not approved by Fresh remains under the ownership of Deep End. There were complex arguments advanced from both sides, and ultimately the court concluded that although legal title had not transferred, particularly as it had not seen any signed contract, there had been an equitable assignment of the rights in the logo to Innocent's movies. Some commentators have been surprised by this decision, particularly given the fact that Deep End were never rewarded with the shares in Innocent's movies. What is clear is that had Deep End made some sensible precautions, most particularly ensuring that the contractual terms were clear and that the payment of shares was made in a timely fashion, it would not have found itself in a court battle and probably would have still been trading today. It's also a salutary lesson for those that commission works, particularly in the early stages of their business. The intellectual property may be of little value at that stage of life in the business, but fast forward 10 years and, as in this case, the growth of the brand and the value of the intellectual property may be exponential, leaving the business owners wishing that they had got the terms and the conditions sorted at the outset. Thank you for joining us for this month's Commercial Legal Bulletin. The videocast and podcast are available to download on the website, together with the written report. We welcome your feedback on the news stories featured today, and please remember to share with your colleagues. We'll be back next month with another update. Until then, thank you and goodbye.